Welcome to the final round of 5th National Welcome to the final round of 5th National Moot Competition 2023, being organized by Center for Legal Studies, Geeta Rattan International Business School on 20th and 21st May 2023. My name is Srishti Bansal and I'll be your anchor for this session. I would like to welcome and thank our judges, Justice Divya Jyoti Jaipuriar, Justice Sangeeta Dhingra Sehgal and Justice Satendra Kumar Gautam for volunteering their time today. I also welcome all the participants present here today. Geeta Rattan International Business School was established in the year 2004. It is affiliated to Guru Gobind Singh Indraprastha University, Delhi and is approved by All India Council for Technical Education, Ministry of HRD, Government of India for Technical Programs and Bar Council of India for Law Programs. We are currently offering postgraduate programs in MBA, MBA International Business and undergraduate programs in BBA, BBA LLB and BA LLB. Our institute has been awarded an A grade by NAC in the second cycle. It is an ISO 9001:2015 certified institute. We have also been rated A+ by the State Fee Regulatory Committee, a fee committee of Government of NCT of Delhi, and has been rated the highest grading A by the Joint Inspection Committee of Government of NCT of Delhi and GGS-IP University. We have been rated grade A by the Academic Audit Cell of GGS-IP University consecutively for the past 8 years. Our institute has been rated number 2 by Times Peace School Survey consistently from 2019 to 2021. And this year, we have been ranked number 1 by Times Peace School Survey for our BBA programs. Adding another jewel to our success, I proudly say that we have been ranked number 49 in the top 150 B schools in India, 34th in to the Ministry of Communication and Information Technology, Government of India on the implementation of Information Technology Act 2000. Mr. Ryder is adjunct professor to the Indian Institute of Management, Lucknow, the Ford School of Management, New Delhi, and the MEP Business School. Adjunct professor to various reputed NLUs. Mr. Ryder has been nominated as a leading lawyer in his areas of practice by Asia Law. With the Agas is a team of 50+ academicians and professionals spread across 6 countries registered under Ministry of Micro, Small and Medium Enterprises. They are certified educational ventures specialized in academic publications. They publish 3 international journals which are indexed like Manubhadra, Google Scholar, etc. Of 14,000 authors, including high number of advocates, professionals and academicians have joined them and are proud to be the first to promote indexing and DOI in Indian legal publishing industry. This round is between Team Code NMC 526 and Team Code NMC 512. Here are basic general guidelines. Each team will get a total of 40 minutes in the final round and additional 5 minutes rebuttal and sub-rebuttal time. Each speaker shall speak for a minimum of 15 minutes. Extra time allocation will be the discretion of the judges. The researcher will not be allowed to plead. All the teams are bound to follow the code of conduct and the rules laid down by the organizing committee. No participating team shall reveal their identity in any form during the competition except by the means of team code allotted to them. Any violation of the provision of this rule shall attract severe penalty or disqualification as determined by the organizing committee. The decision of the organizing committee in this regard regard shall be final and bounding without scope of appeal. Now, with the permission of our judges, we shall begin the round.
The council seeks permission to open the council is appearing in the matter of United Bank of India versus Mr. Arvind Shah on behalf of the appellants. Yes. For the appeal filed under High Court jurisdiction. Your Lordship, there are three issues mainly involved in the present case. The council will be dealing with the first and second issue. My co-counsel will be dealing with the third issue. If your Lordships are well versed with the facts, may I proceed with issue number 1? Issue number one tells that whether the appeal filed before this Honorable High Court of New Delhi is maintainable or not. The council humbly submits that the present appeal shall be maintainable under Article 226 of the Indian Constitution 1949, read with Section 378, subsection 4 of CRPC. The Article 226 give High Court the ability to issue instructions, orders, and writs to any person or authority, including the government. Whereas Section 378, subsection 4 states that if such an order of acquittal is passed in any case instituted upon the complaint and the High Court on an application made to it by the complainant in this behalf grants a special leave to appeal from the order of acquittal, the complainant may present such an appeal to High Court. In Bandhwa Mukti Morcha versus the Union of India 1984, it was held that the Article 226 has much broader scope than Article 332, as it gives High Court the power to issue orders, directions, and writs not only for the enforcement of fundamental rights but also for the enforcement of legal rights that are granted to the disadvantaged by statute and are just as important as fundamental rights. The Lordship, the Council would further like to state the authorization and unauthorization part from the IT Act book. May I? IT Act.
You may argue the way you want to.
Much obliged. All cyber crimes contained under Section 43 of the IT Act require common trigger, the lack or excess of authorization. Section 43 defines the term as without permission of the owner or any other person who is in charge of a computer system or computer network. An authorized act is one which is done without authority, made without actual implied or apparent authority in cyberspace, when an unauthorized user gains the access to data. In the page number 179 of that act, data diddling is misusing of data by an employee with minimum computer knowledge. In this case, Mr. Shah had been working from 2002 to 2006, which means he is working for 16 years and has the knowledge has the total knowledge of the company, and he joined the company as a computer operator. He knows everything, how the company works, how the system works. He knows everything about it. And data diddling, Mr. Shah has done data diddling is liable for data diddling. In Common Cause versus Union of India 2018, the Honorable Supreme Court stated that the High Court has been given the power and jurisdiction to issue appropriate writs in the nature of mandamus, certiorari, prohibitio, quo warranto, and habeas corpus for the enforcement of fundamental rights or for any other purposes under Article 226 of the Constitution. As a result, the High Court can issue a relief not only for the enforcement of fundamental right but also for any other reason which might include the enforcement of public responsibilities and by public authorities. If the lordships are convinced with the argument submitted in the issue number 1, the council seeks permission to proceed with the issue number 2. The council seeks permission to proceed with issue number 2, whether the Mr. Shah is to be held liable. The council humbly submits that theft has been committed by Mr. Shah. It is pertinent to be noted that consent for taking anything for a person's possession may be implied or expressed. Even a person who is authorized by the owner for such purpose may also give consent. In Pyarelal Bhargav versus the state of Rajasthan 1963, in this case it was held that removing of a file from the office and giving it to the third party who is not an employee for personal profit constitutes the offence of theft. It is immaterial for what duration of or time period the file has been removed. The moment a thing is moved from its place with the dishonest intention out of a person's possession without his consent, establish the offence of theft. Hence, the evidence shall be taken into consideration to the Honorable High Court that Mr. Shah has committed theft in this matter. Section 378 of Indian Penal Code defines theft. In the book of cyber law, page numbers 82 and 83 defines what is cybercrime and its punishments. Cybercrime is any illegal act fostered or facilitated by a computer, whether the computer is a crime. An instrument is used to commit a crime. In this matter, according to the fact sheet, page number 1, para 3, it is stated that Mr. Shah has used external hard drive to steal the customer's data. In this case, Mr. Shah has committed cybercrime. Section 114 of Indian Evidence Act 1872. The court may presume that the existence of any fact which it thinks likely to have happened, regard being had to the common course of natural events, human conduct and public and private business in their relation to the facts of the particular case. Illustration that a man who is in its possession of stolen goods soon after the theft is either the theft or has received the goods knowing that to be stolen unless he can account for his possession. Hence, the excellent attempt was made to hide the merits failed miserably by the respondent because the stolen data was found in the possession of respondent. Dishonest intention on the part of Mr. Shah without consent is one of the most essential ingredients to bring home the guilt of theft, which is made out when the transfer of possession by theft is done with the intention or either causing wrongful gain to one person or wrongful loss to another person. Hence, Mr. Shah, the respondent, must be held liable for committing theft. The council would like to. The council would be stating section 66C of IT Act.
Who's showing the time?
Punishment for
It should show it actually here now.
So that we want to put your watch here.
You just put your phone or whatever because we can't see it otherwise. Sorry. Yes, please carry on. Or we use our phone. So don't waste time, you carry on please.
Section 66C, punishment for identity theft. Whoever fraudulently or dishonestly make use of the electronic signature, password or any other unique identification feature of any other person shall be punished with imprisonment of either description for a term which may extend to 3 years or shall also be liable to fine which may extend to ₹1 lakh. Furthermore, property stolen is found in the possession of Mr. Shah. Theft with regards or to the data and information is an aggregated form of the theft to give greater security to property deposited in a computer. Even the possession of a personal data and information about the customers was found with the respondent. Soon after the theft, it was pursued be prima facie evidence of it either being stolen or being received by the accused. Knowing to be stolen, have been stolen by him. Respondent has no reasonable explanation as why he had stolen and why the data was found from his IP address. Respondent miserably failed to give the reason as to how he had files and data and customers information, even though he was no longer a part of United Bank of Indira. Furthermore, customers' privacy has been infringed. The right to privacy is an inalienable human right which inheres in every person because he or she is a human being. It is also recognized as an independent personal right. Privacy is an individual condition of life, categorized by seclusion from the public and publicity. Respondent unlawfully copied and transferred the personal data and information about the customers with a malicious seclusion from the public and publicity. Respondent unlawfully copied and transferred the personal data and information about the customers with malicious. If the Lordship is convinced with the arguments, my co-counsel will be dealing with the issue number 3. Watch out.
Council seeks permission to approach and rise. Much obliged, Your Lordships. May it please this Honorable High Court that if they are convinced with the arguments and pleadings presented by my Speaker number 1, Council seeks permission to proceed with issue number 3. Much obliged, Your Lordships. Your Lordships, the main issue here we are dealing with is whether the bank is equally liable for the breach of data or not. It is humbly submitted before the bank, before this Honorable Court, that the bank had taken all the necessary precautions and had invested a large sum amount of money to safeguard the sensitive information of the customers, and no, it's with the consent of it was a consent that he had a malicious act for making. Hence, the bank is not to be held liable for this particular act. For this, the council refers to the Black Law Dictionary, wherein cyber offense, cyber theft has been defined. The act of using online computer service, such as one of the internet, to steal someone else's property or to interfere with someone else's enjoyment of property. In this particular case, we can definitely come to a conclusion that data itself is a property which belongs to a particular person, and the property was stolen by Mr. Shah, which was in the possession of bank. It was done with a malicious act. He had a bad intention. He was removed from the bank because of his declining performance. To take a revenge, Mr. Shah did this to take a revenge from the bank and affect the reputation of the bank. Furthermore, there are examples cited of cyber theft and hacking into banks' computer records to wrongfully credit one account and debit another. He had taken sensitive information from the bank. That was account numbers, Aadhaar card details, PAN card details, which are very sensitive towards the customer, which is not to be given to any third party. Mr. Shah did the same. Computer records to wrongfully credit one in debit and interfering with the copyright by wrongfully sending protected material over the internet. The moment he copied his data from the computer, he also copied the sensitive information. When we talk about sensitive information, we mean sensitive information which is regarding to a personal space of a person. The personal space cannot be infringed by any third party. Even though the person is a state, the person can be the government. The Constitution guarantees under Article 21 the right of privacy cannot be infringed by any person, and he has violated all those terms. The council would like to request the judges to kindly refer Section 72 of the IT Act. Section 72 of the IT Act. IT Act has been submitted to the honorable judges. Section 72. The council seeks permission to proceed.
Yes, please.
Section 72 of the IT Act attracts the breach of confidentiality and
I'm asking one thing, what is the coded evidence against the Mr. Shah? You not explaining the law, the law there. You are not going to the law, you are going to the facts of the case.
I definitely-
There is a basis of evidence, but the evidence is against the person, one is against the
answering your
what is the primary, what is the secondary evidence against the person?
for this, the council's request the honorable bench to kindly refer the Moot proposition page number 2.
Yes, please.
The bank immediately launched an investigation. The moment we came to know that there was a breach committed, the bank immediately launched an investigation. Which
Evidence was there, FIR was there against you, what evidence?
this is before the FIR. This is before the FIR. This has led to that FIR. Indeed, this is the precedent. The banks immediately launched an investigation which revealed that Mr. Shah had accessed the bank's computer system months before and had copied numerous files and documents without authorization.
Now that can be as a part of his job also, no? Because earlier he was working there.
And definitely. So for that, I would request the honorable bench to kindly come to the Moot proposition page number 1. May I proceed? It is written that he was a grievance officer. He had nothing to do with the sensitive information. He was not the head of the IT.
What is the nature of this function?
Grievance officer is basically if the customer faces any fraud or if he gets some issues from the customer, it is his work to elevate that problem and not to solve the problem. He is only the grievance officer. He is not the grievance solver officer. The bank is to be the one. Yes.
This officer,
Grievance officer. Sir.
What are the terms and conditions of this employment?
See, there are two things. You are missing one thing. He joined as a computer operator.
Indeed.
Gradually, he became head of the IT department and additionally designated as a grievance officer. So he was having dual charges. Grievance officer, see, and the head of the IT department. So he was in his rights to access the data, not as a grievance officer, but also head of the IT department as well.
He was, I agree to this point, my lord, but definitely I would put this point in front of you. Then when we were terminating him, we revoked all the rights which he was having. Indeed, he was having all the rights when he was there in the bank. But the moment we revoked the contract with him, the rights come to an end. So copying those data shows that it was unauthorized act. So after termination, it is very clearly mentioned.
You found later on after termination the data will be.
I'm unable to.
The question is, see, the data was found. Was that data taken by him at the time while he had access to the computers and he was on the job, right? As an IT guy? Or was it taken after when you terminated him and then he assessed it and then he
For this, I would definitely, the council is permission to proceed and answer your question. If we come to the fact sheet, indeed. Here it is written, he used the SQL injection bypass. There's a term called SQL injection, which he invoked in the bank system after leaving the company. Post his revocation, he used this virus hacking technique to remove the data from it. And the IP address itself is mentioned belongs to Mr. Shah.
Just one more thing over here. When you are talking about the liability of the bank, the customer data that is there in the bank's possession, that is a very most important data which is there in the bank's possession, and it must be encrypted. if it was not encrypted and it was copied so easily, then how come bank's liability is not there? Because encryption of data is the primary responsibility of the bank.
Sir, definitely.
He was the only person who had access to the data.
Being
No
the
other
IT.
official.
So what is done?
The facts are silent about those factors.
So if I will not elected,
Council is motion to proceed. Much obliged, Your Lordship. To answer the questions, I would definitely request the Honorable Bench to refer para number 3 of the fact sheet, which clearly mentions that United Bank of India is currently, till now, is investing heavily in upgrading its security and data protection systems. The bank is correct. The bank had hired top security experts and is implementing state-of-art technology to safeguard its operation and customer data. The process is still going on, it is clearly mentioned, but the bank is also urging the customers to be vigilant and take necessary precautions to protect their accounts and personal information in the meantime. There are so many laws in India. I would like to quote an example here. There are so many laws in India. Still there has been crime committed. That doesn't mean the law is not a problem. The crime is not a problem. The crime will definitely happen, but we are definitely upgrading, we are bringing amendments. We know whatever we do, the criminal will be one hand further to us. So we are doing our part, customers are doing our part. But these people who are having malicious intentions, are having revengeful attitude, are affecting the country and affecting he took the data which can affect the national security too. There could be customers who might be high profile customers. So he being in the company from 2002 to 2016 already knew that what are the benefits if he takes this. He was elevated by the bank itself. It was never the bank who disregarded him. It was because of his mental capabilities and because of his declining performance we had to revoke. We had to take a cognizance of the matter. We could not ignore because it was affecting the services of the company, of the bank. Hence, it is the submission from the council that the bank was not at a fault. It was Mr. Shah post his removal to take an revenge from the company, from the bank. He didn't want it to go. If he had a revenge and he thought that bank is at a fault, he could have taken the legal matter. He could have knocked the doors of the courts, but he didn't do so because he had no valid point. So he did this to affect the bank's reputation. This is a submission made by the council. If the honorable judges are convinced with the facts, the council seeks permission to proceed. Much obliged, Your Lordship. Much obliged, Your Lordships. The council would put light on the case of Mohit Shah. Mohit Shah, in this particular case, the respondent was held liable for extracting the data unauthorizedly. We have already submitted the authorization and authorized data books to this honorable bench. The judges are convinced with the arguments. The council seeks permission to proceed. Yes. Much obliged, Your Lordships. Data theft in India is mostly governed by the IT Act, that is Information Technology Act 2000. The Honorable Court shall pay heed to the fact that Mr. Shah was separated from the bank, which shows the vigilance of the bank which took into the cognizance of the matter as mentioned very clear in the fact sheet. Section 43, the council would request to kindly refer Section 43 of the IT Act. It has been marked. Talks about the definition of IT, or talks about the data theft. And once we proceed, I would request the honorable bench to see Section 65, 70 and 72 of the IT Act, which talks about the penalties imposed in the data theft. Certain sections of IPC can also be invoked in the data breach. The council requests this honorable bench to kindly refer the Section 403, which deals with the data, which deals with the imposition of criminal penalty. It is also a criminal crime, criminal act. Penalty for dishonest misappropriation or conversion of movable property. As referred by me and as defined by me, it is a movable property. Hence, using it in a wrong manner, moving it from somebody else's possession to his unauthorized possession, he is committing theft, and he is now also liable under Section 378. He abstracted the data and stored it in a hard drive, floppy, pen drive, and it was stolen by him. Hence 378 can be invoked. It is very clearly mentioned in the fact sheet. If the judges are convinced with the facts presented, the council seeks permission to proceed.
Which section you read is Section 406 of the IT Act?
403.
Yes, you are right. Why do you read 409 of the IT Act? Which was the class of this committee of our bankers. You are the bankers, man. You are the bankers. I can't be involved at that.
The council would like to refer to request to refer. To answer the question, the council submits that whatever acts Mr. Shah has done, he has done his post-employment revocation of his contract. Bank is not to be held liable because vicarious liability ends when the revocation of the contract was done. Post his acts, even though he is committing any kind of act, the bank is not to be held liable because bank had taken the appropriate step by revoking all the data, by revoking all the systems access he had, and then he was told to copy his data.
As committed by him, though he is serving to that. After the termination of this act was revealed, not a completely crime.
Indeed.
As per the 409 Act,
It cannot be, certainly not, Your Lordship, because in this particular, it is very clearly mentioned, agent, banker, he was not the agent of the bank, and if he had committed, yes, Your Lordship. If he was there in the course of employment, then he can be held liable. By during his course of employment, if he could sell the data, if he had taken it unauthorizedly, then he could have held liable. But he took it post his removal from the bank. So 409 does not attract in this particular case, Your Lordship.
with the exception of 409, there is an order to sustain conviction on the section 409 to Indians are they are accepting of the property on which the accused is bound to be bound to count for and committed for criminal breach of trust. And in the last month, Samatiya versus State of Bihar to file
It goes against Mr. Shah.
yeah.
It goes against Mr. Shah because it is telling it is to be held liable to the accused and not to the agent. If the Lordship is convinced with the arguments presented, the council seeks permission to proceed. Much obliged, Your Lordship. The council the council seeks your permission to kindly note this particular point that the right of privacy is a fundamental right under Article 21 of Constitution that enables the individual to control the use and disclosure of the personal information. The right can be exercised by the individual to prevent collection, use and disclosure of the personal information. There is a danger that the existence of computerized data about an individual could be used to create inaccurate or misleading information. In this part, I would request the Honorable Court to kindly refer the fact sheet in this particular section. The council is trying to prove that the investigation revealed about Mr. It is on page number 2, paragraph 3. The investigation also revealed that the customer data has been sold. Can the council proceed? Who had used the data to commit theft and financial fraud. Third paragraph, page number 2, Moot proposition. You want me to submit this? The investigation also revealed, paragraph number 3, the investigation also revealed that customer data has been sold to a group of cyber criminals who used the data to commit identity theft and financial fraud. The council, when referred that it was used to commit the financial fraud and it was a misleading information taken by Mr. Shah and then sold to somebody else, the cyber criminals, that is a third party again. The bank had to spend a significant amount of money on the damage control. Now again the liability of the bank is not here, but only for the customers. Rather than fighting with Mr. Shah, first we protected our customers and then we knocked the door of this honorable court to get justice. Of money, including notifying the affected customers, providing them with identity theft protection services and enhancing cybersecurity measures. So the moment we came to know that there are more other measures which they are invoking, we again invested a lot and then we tried to upgrade our systems. As we were already doing it, we tried to do it more to protect the customer data services. For the sake of justice, just for 5 minutes, the council seeks permission.
You should say no, when you are sitting here, then you should please tell us how many times.
Just 40 minutes.
Okay, right. So, how much time is left?
Sir, 26 minutes. So, whole team total of 26 minutes.
14 minutes to 26 minutes. Okay. So 14 minutes. 14 minutes.
May the council proceed?
One query there.
Yes.
You said about the identity theft and the financial fraud. Apart from that, there are some significant amount of money. You explain this part, how much money that is lost.
The facts
All
are
the
silent
financial fraud
about
and
it.
the
The fact is silent about that.
silent.
The fact is silent about it. The fact is silent about it.
Silent and you can.
We actually asked, but it was not.
They can improvise. If the fact is silent, then you can improvise.
Definitely. Noted, your lordships. May council proceed? Not proceed. Thirdly, the council would request this honorable court that the trial court consequently erred in giving a recent judgment. It is humbly submitted before this honorable High Court of Delhi that when the trial court has not taken evidence into consideration and has given ambiguous reason to back its judgment, then it is an unreasoned judgment. The concept of reasoned judgment is a part of basic rule of law and is a requirement of procedural law. The reason should not be ambiguous and it should link the material on record and the conclusion which the court has arrived. There must be an application of the laws in the facts that have been produced before a court, which was lacking in this particular case when it was being tried in the lower court. Here the council would like to seek an example that God himself did not pass a sentence against Adam without giving him a valid reason. We knock the doors of the court to get a valid reason for either acquittal or conviction of a particular person who is involved in this particular crime, which is very severe and threat to national security. Non-compliance with this cardinal principle leads to denial of justice. Giving an ambiguous reason is a violation of fair play and natural justice. And in a case where there is a serious violation of natural justice, the court can declare the action is invalid. This honorable court has the powers to declare that the lower court's judgment as invalid. Hence, the unreasoned judgment, the council humbly prays, should be overruled and the justice should be done by this honorable court.
What is the illegality in the judgment passed by the trial court?
In the lower court, my lord, in the lower court, the lower court has acquitted Mr. Shah on the reasons. Fact was silent about this, the charges presented against him, because in the fact sheet it is only written certain provisions of IPC and ITI. So the facts are about silent, but still he got acquitted. Hence, we had to knock the doors of the higher court for the sake of justice. May I proceed? Lastly, to conclude, the burden of proof is asserted on the respondent here. The fact that whoever claims a legal right before the court, depending upon the existence of certain facts that he asserts and prays to the court to give a judgment in his favor, must prove those facts. To be proved and the burden of proof lies on that person. The council would like to request the honorable bench to. Thirdly, Mr. Shah is guilty of theft of personal data and sensitive information about customers under Section 378 of Indian Penal Code 1860. To prevent Mr. Shah and his associates to share, use, transfer, sell the data which he had illegally and unlawfully acquired from the computers of the bank. Lastly, compensation to be granted to the appellant and the all affected customers. And to pass any order, direction or relief that it may deem fit in the interest of justice, fairness, equity and good conscience for his act of kindness, the appellant, as in the duty bound, shall forever pray. The council seeks permission to rest. Much obliged, your lordships.
The council seeks permission to do the rest. Such a grand motion.
Good afternoon to the Honorable Bench. If it may please, the Council seeks permission to address the bench as a lordship. Much obliged, lordship. The Council is appearing before the Honorable Court in a matter of United Bank of India versus Mr. Arvind Shah on behalf of the respondent in response to the petition filed under Article 226 of the Constitution of India 1950. The respondent submits that there is no violation of fundamental rights of accused person. The Council seeks permission to begin with the statement of facts. Much obliged, Your Lordship. The United Bank of India is a large bank in the country of India, but the bank's IT infrastructure remains outdated and its IT system have been reported as being vulnerable to cyber attacks and data breaches. It suffered over 5 cybersecurity incidents in past 5 years. It has been criticized for exposing its customers to an ongoing risk of financial losses, identity theft, but officials deny claim to sensitive customer data being stolen. Banks came with this issue by investing heavily in cybersecurity and hiring top cybersecurity experts, but bank insists its customers to be vigilant and take necessary precautions to protect their accounts in the meantime. Mr. Arvind Shah was a former employee of UBI and joined the bank as a computer operator in 2002. Rose through the bank to become the head of IT department and the bank's designated grievance officer. He maintained bank's computer system and customer data, but due to some complaints of his colleagues about his inefficiency, the bank in the year 2018 announced and revoked his access to bank's computer system without any prior notice to Mr. Shah. 6 months after termination, there was a big data breach incident in the banks which resulted in the theft of confidential customer data. Attacks was performed using hacking tool called the SQL injection to bypass bank security system and gain access to the customer data. Many customers had suffered financial losses and bank filed a criminal lawsuit against Mr. Shah under various provisions of the IT Act 2000 and IPC 1860, claiming that Mr. Shah had unknowingly copied sensitive data in an external hard drive. The Council seeks permission to proceed with the pleadings. Much obliged, Your Lordship. Your Lordship, the first issue is whether the writ petition under Article 226 of Constitution of India be maintainable under High Court or not. It is humbly submitted before the court that the writ petition is not maintainable under Article 226 of the Constitution of India, as the bank is a private entity. Thus, the respondent is also a private employee, not a public employee, and the private institution cannot file a writ before the High Court. Writ jurisdiction of the court is generally limited to public authority and cannot be invoked against private individual or entity in the absence of public duty or obligation. Writ is a command issued by high courts and addressed to any person, corporation, or inferior courts of judicature, requiring them to do something therein specified, which appertains to their office and which the court holds to be consonant to right and justice. It is used principally for public purposes and to enforce the performance of public duties. It enforces, however, some private rights when they are withheld by public officers. A writ is generally not issued in the following situations. First, against a private individual. Second, if the duty is questioned is jurisdictionary and not mandatory. Third, against the president or governors. Fourth, to enforce the private contract. Fifth, against the chief justice. Here, in this particular case, the bank is a private bank and cannot come under a writ jurisdiction of the writ of mandamus under Article 226 of the Constitution of India. Hence, a writ has been granted as a measure to check the power of the executive. The Supreme Court and High Court, through their orders, strive towards ensuring that the writs act as a tool of judicial constraint to actions of the authorities that are unfair, unreasonable, and against the interest of the general public. In the case of Bindi Limited versus Sadasivan, the apex court in this case observed that a writ of mandamus or remedy is preeminently a public law remedy and is not generally available against private. Your Lordship, can you refer this section number 4?
Just one thing. I was reading your memorial here. Just come to page number 10. Do you have a copy of your memorial? Yeah, number 12, page 10. You are writing the respondent hereby submits that the petitioner has approached Honorable Supreme Court of India under 226. It's not Supreme Court. It's a High Court. The position says High Court. The fact says High Court. And 226 and there's a difference. 226 you cannot go to Supreme Court under 226. Supreme Court you have to know all the
Pardon, Lordship, what is mistake?
Actually, it is a typographical mistake, but you should be careful. You should be careful.
See, Article 226 is applicable in the High Court only, not in the Supreme Court. You have written approach the Honorable Supreme Court. It may be just a typographical mistake, but that won't be right, because over there it is Article 32. Over in the High Court it is Article 226. You have written Article 226 and you have written Supreme Court. That's what we are pointing out.
In the bottom also you written
It's at the bottom. Full court is okay. Correct. But you should stop, please. Typographical mistake.
Please come.
Shall I?
Yeah, yeah, further.
Much obliged, Lordship. Can you refer to page number 15, paragraph 4?
Yes.
15.
Yes. Then
In the very landmark case of Universal Hospital A1 AIM LLC versus Yes Bank Limited, the Honorable Court held that Yes Bank, being a private bank, is not amenable to writ jurisdiction of this court. Mere investment by the State Bank of India (SBI), having shareholdings of 30% in the respondent, Yes Bank cannot be termed as a state. The State Bank of India is not a government body. It is a statutory bank, and therefore holding of shares by the SBI cannot be said to be a state or authority as defined under Article 12 of the Constitution of India. Similarly, the Life Corporation of India (LIC) is having invested 4.90% also cannot be said to be a state as defined in Article.
Today, I, Bhumika, and I, Persania, on behalf of Idaraga International Business School, welcomes you all to the valedictory ceremony of 5th National Moot Court Competition organized by Center for Legal Studies, Idaraga International Business School. We offer a very warm welcome to our esteemed guests. Justice Dr. Sangeeta Dhingra Sehgal, retired from Honorable High Court of India. Shri Satinder Gautam, Presiding Officer, Special Court, NI Act at Dwarka District Court. Shri Justice Divya Jyoti Jaipuriar, President, Delhi, District Consumer Disputes Redressal Commission. Our Chairman Sir Shri Anand Jindal, esteemed Vice Chairman Sir Shri Anirudh Jindal, respected Dean Ma'am Mrs. Prati Jindal, our Director Sir Professor Dr. Vikas Nath, our respected teachers, all the worthy participants who joined us here today, and our fellow organizing team to the valedictory ceremony.
Introducing Geetharathan International Business School. Geetharathan International Business School was established in the year 2004 under the aegis of Romini Education Society. The society is currently running various other successful institutions in Delhi, like Geetharathan Institution of Advanced Studies and Training, Geetharathan Jindal Public School, and the Sorghum School. Geetharathan International Business School is affiliated to Guru Gobind Singh Indraprastha University, Delhi, and NAC aggregate A++ is approved by All India Council for Technical Education, Government Ministry of HRD and Government of India for Technical Programs, and Bar Council of India for Raw Programs. The institute is conducting programs like MBA, MBA International Business, BBA, both first and second shift, BBA LLB and BLLB. Yes, is NAC A accredited institute and has also been rated grade A by the Academic Audit Cell of DGSIPU consistently for the last 5 years. GIBS has been rated as A+ by the State Field Regulatory Committee by Government of NCT of Delhi, and it has been awarded highest rating A by the Joint Inspection Committee of Government and Delhi and DGSIPU. GIBS has been ranked number 2 by the Times B School Survey for 2018, 2019 and 2021. And now this year, GIBS has been rated number 1 by Times Business School Survey in the BBA program. GIBS has been ranked number 49 in the top 150 B schools in India, 34 in the top 100 private institutes in India, and 19 in the top 20 B schools in MBA program by the Times Business School Survey 2022. Central for Legal Studies has been set up by the Geetharathan International Business School in the year 2016 for imparting legal education CLS, Central for Legal Studies. GIBS has been emerging as one of the most prominent law schools of the country, providing 5-year integrated program for BLLB and BBLLB.
Now, we request you all to kindly have a look at the corporate video to get a glimpse to know about GIBS.
It's a driving force that leads you on a path of success.
National Moot Court Competition is an annual national level competition organized by the courtroom, the Law Society, Center for Legal Studies, Geetharathan International Business School. It brings together students from different law schools of the country to compete in a fast-pacing and challenging professional environment. It aims at giving exposure to law students on important issues arising in the contemporary socio-economic and legal environment. It is very proudly we conducting our 5th National Moot Court Competition 2023 this year for 2 days, that is 20 May and 21st May. We are delighted to host teams from all over India with participation of 34 teams from some of the renowned law colleges of India, namely Banaras Hindu University, Central University of Kashmir, Himachal Pradesh National Law University, University of Lucknow, Maharashtra National Law University, among others.
Now, we request you all to kindly have a glimpse at the behind the scenes of 5th National Moot Court Competition.
the 5th National Football Competition 2022-2023. National Football Competition is an annual national fest. National level competition organized by the Law Society, Center for Legal Studies, Gita International Business School. It brings together students from different law schools of the country to compete in fast-paced and challenging professional environment. In recent years, Moot could have emerged as an indispensable part of legal application. This activity gives the student an opportunity to sharpen their skills for extensive research and precise argumentation by exposing them to the simulated environment of the courtroom. It is a moment of immense pride to stand before all of you today at the closing ceremony of NMC 2023. It is my immense pleasure to welcome our guest, Justice Shri Satendra Gautam Sir, Presiding Officer, Special Court Dwarka, Shri Divya Jyoti Jaipuria Sir, President, Delhi District Consumer Dispute Redressal Commission, Dwarka, and each and everyone present here. Our today's guest for the day is Justice Dr. Satendra Kumar Gautam. He is a presiding officer at Special Court, Dwarka District. He retired as an additional district judge, Dwarka Court in 2021. He completed his LLB in the year 1985 from University of Delhi and completed his diploma in international law, labor law and personal management in 1986 from Indian Law Institute. He has completed his LLM in 2003 and PhD in 2014 from Kurukshetra University. May I now request Director Sir to please welcome our guest with sampling. Mooting cannot be gained in classes. The involvement of all the young law students in the competition has not only infused vibrancy and fresh perspective, but has also served as a catalyst for innovation and creativity. It is through the overwhelming participation we witnessed novel arguments, persuasive advocacy, and in-depth understanding of the complex issue at hand. Onward and forward is the way always. You uphold the principles of justice, equity, and fairness. With these words, I would like to thank all of you for patient hearing to me and would like to convey my best wishes and acknowledge the valuable role played by the organizing team and the participant for holding such a successful competition that has attracted participation from law colleges all over the country. Last but not the least, I would like to congratulate the Faculty for Center of Legal Studies who have worked tirelessly to ensure the success of this competition. I am so sure that their guidance, expertise and encouragement has made a lasting impact on these minds, shaping them into competent legal professionals they aspire to be. Thank you. Have a great day.
Thank you so much, ma'am. Now, we invite our guest, Shri Satendra Gautam, to kindly come on stage and enlighten all of us with the words of wisdom.
Good afternoon, everyone. Thanks for inviting me here. I'm not a speaker, I'm just a judge. I'm writing a judgment only. Before inviting me, I told them that I'm not allowed to speak here before my junior colleagues. One thing I observed here while holding moot courts, all these readers have been reading from the books. They are reading word by words. I think they are not prepared up to the mark as required by the judges of the High Court. If they have filed a petition before the Honorable High Court for 2 to 6. In the High Court, they are not allowed to read by word from the judgment, 2 judgments and each and every sections. They must be prepared in all the ways to speak, not by the verbatim. So I advise my brothers, all the leaders, to prepare well by speaking just like a leader, as mentioned here by giving the tips as they are the leader of futures. To become a leader of futures, they should follow the principle of equity, justice and good conscience apart from the legislation. Whatsoever mentioned in the legislation, that is the primary things. But apart from that, whatsoever being followed by the circumstances and the facts, while you are being trading or while dictating the judgments, you must be well aware about the equities. Equity is based on the principle of mitigating, aggravating circumstances. As such, with this advice, I close my speech. Thank you for that.
Thank you so much, sir. Your words were inspiring. Now, we invite a guest, Justice Divya Jyoti Jaipuriya, President, Delhi District Consumer Disputes Redressal Commission, to kindly come on the stage and enlighten all of us with his words of wisdom.
Thank you very much, and a warm good afternoon to all of you. But before I speak anything, I just want to clarify one thing, that when you use the word justice, don't use it very lightly. The word justice before a name is used only before only for the name of a judge who is a judge of a high court or a supreme court. A district court judge or a lower judiciary judge, they are not addressed as a justice. I am also a president of the district consumer commission, so I am also not, as of now, I am not entitled to have that fixed in my name. So when you use the name, call someone as justice, use it properly, and then only with a judge who is a judge of the high court or supreme court, serving or retired. Yes. Now with that, it was a wonderful experience today, and then I saw some of the best meetings that I have ever seen. The one thing that Gautam sir, he has already pointed out, that when you are in the court, you are not supposed to read out from your memorials. So, a word of advice to all of you, that as a law student, you must go and witness that how different courts work. You must go, as it must be a part of your curriculum as well, but you must also go to different high courts, different district courts. If you have access to the high court, that's a good thing. In Delhi, they have access to high court, supreme court, different commissions as well, trial courts as well. But in other parts of the country, you don't have access to the supreme court, but yes, you can go and see the proceedings in the high courts as well. And the proceedings in the Supreme Court nowadays, they are coming on the website of the Supreme Court as well as on the YouTube channels. So go and see all those channels. Because tomorrow you are not going to be a lawyer or someone who is going to just go and take a passover or a adjournment in the matter. So you have to argue the matter, you have to present your case, and you have to present your case effectively for your clients. So unless and until you learn how to do a proper advocacy and how to, you start learning from the very beginning, it will be very difficult, because when you come, after finishing your law, when you come to the court, if you're not well prepared, it takes a lot of time to come to a particular level of platform. But as of now, if you are as a law student, I would suggest that as of now, you start going to the courts and then start seeing the proceedings, and then some of the judgments, some of the cases like in Supreme Court also, some of the constitution bench judgments cases, these are broadcast live on YouTube and Supreme Court websites. Go and watch them. Given the earlier proceedings of the High Courts and Supreme Courts, these are also there available on the YouTube. So that's how you would learn that how you have to articulate the cases, and you have to present your case before the judge or in the court. Because the main purpose of you is to present your case effectively, and so effectively that at least your client is satisfied that yes, my lawyer has presented the case properly, and then whatever the judgment would be, but at least my client has presented, my advocate has presented my case properly. So that's the thing that you have to always keep it in your mind. Law can be interpreted in many ways. If you ask a lawyer to interpret a law, two different lawyers would give you two different interpretations. So law is always, there is always a scope of interpretation, and your interpretation that must be supported by some judicial pronouncements, or if there are not judicial pronouncements, then how that law should interpreted should be judicious. So that way you have to interpret law. So that's very important, that you have to, when you read law, when you have to read judgments, you have to see that how you are going to prepare yourself and how you have to interpret the law. And I will end this with saying that when you go to the court, there are two things that you have to do in the court. Either convince the judge or confuse the judge. Likely speaking, the first thing is that you have to be very effective, and your arguments must be very effective, so that you can convince the judge about your case and then get a favorable judgment. But even if you are not able to convince the judge, you can confuse the judge. Today I have seen the voting in the final round, and some of the arguments that were led over there, these were not in the declarations, but improvisation was very good, and then we were very convinced about the arguments. And I am saying this off the record, but the margin of error and the margin by which the winner team was selected, that was very less. So both the teams who were there in the final rounds, best of luck to you, and to all of you, best of luck. Thank you.
Thank you so much, sir. Your words were truly inspiring.
We would now take the opportunity to invite our extremely dedicated and hardworking organizing committee members on the stage, who have spent months tirelessly planning to make this event a grand success. With a huge round of applause, let us welcome Devika Singh, Neha Chaudhary, Bhumika Gupta, Gaurav Damya, Ayush Sharma, Shivika Kakkar, Komal Garg, Paras Jain, Ashmi Jha, and Navya. I would request Director Sir to please felicitate our team members, their certificate. And the judges.
स्कोर टीम तो कौन टीम ही है
Next up we have Best Memorial, Chinmay N. Dixit. I'm sorry, we have the Best Mooter, Chinmay N. Dixit, NMC 503, JSS Law College, Mysore, winning a prize of ₹10,000 and certificate and a trophy.
Second best researcher goes to Pushpit Mathur, NMC 510, Deshri Naval Mal, Firodabad Law School, Pune.
Moving on, we have Best Researcher, Kanishak Taneja, NMC 518, Amity University, Gurgaon, winning a prize of rupees 10,000, a certificate and a trophy. We do not have it here. Now, for the declaration of the Memorial Award, we would like to call upon stage our dignitaries from Vithi Awas to please present the award. Please welcome Mr. Gyan Prakash Kesharwani on the stage. For the second Best Memorial, we have Abhas Raj, Koparti Bhaskar Narayana, Praswal Kumar, College Faculty of Law, Banaras Hindu University. The Best Memorial goes to Saloni Agarwal, Saurabh Sabwani, Mahi Agarwal, rupees 10,000, trophy and certificate. The runner-up of National Moot Court competition is Team Court NMC 512. Speaker number 1, Trisha Soman. Speaker number 2, Sanskriti. Researcher, Dhanajay Chaudhary. College, Vivekanand Global University with a cash prize of rupees 25,000. Certificate and a acknowledged partner, Strybord and Vithi Awas. Strybord is a full legal consulting firm with cutting-edge specialization in information technology law, intellectual property and related services.
Their vision continuously provide invaluable and high-quality strategic advice and services to innovative companies, organizations, and industry leaders. Rodney Day Ryder is the founding partner of Scribo. He is presently advisor in the Ministry of Communication and Information Technology, Government of India, on the implementation of the Information Technology Act 2000.
Vidyagas is the team of 50 plus academicians and professionals spread across 6 countries registered under Ministry of Micro, Small and Medium Enterprises. They are certified educational venture specialized in academic publication. They publish 3 international journals which are indexed like Manupatra, Google Scholar, etc. Over 14,000 authors, including high number of advocates, professionals and academicians have joined them. And are proud to be the first to promote indexing and DOI in Indian legal publishing industry.
The trophies for the event are sponsored by our gifting partner, Manoram Creations. Manoram Creations is a leading trophy manufacturer and supplier in Delhi and NCR, all over India. They offer elegant and top quality trophies and awards at very reasonable price. Their expertise lies in the offering all types of trophy like acrylic trophy, cup trophy, wooden trophy, football trophies and all the other awards and trophies.
The 5th National Moot Court Competitions has